Good morning, and may it please the court. I am Seth Berlin, and I would like to reserve 7 minutes of my time for rebuttal. I represent specially appearing defendant-appellant Blogwire Hungary, Zelemi Alkotást Hasznosító. Mercifully, since the case began, the company has been renamed Kinjo in Hungarian and Kinjo in its English variant, and I will, for ease, refer to it as Kinjo. Kinjo is a Hungarian LLC. The initials in its name, KFT, are the Hungarian equivalent of LLC, and it is principally a software development company. It's been a defendant in this dispute for 2.5 years, even though it has no contacts with Florida and played no part in the torts alleged by the plaintiff here, Terry Bollea.
Mr. Berlin, I wonder if you could, before we get further and get into the merits, if you could address the issue of jurisdiction, because looking at the sequence of events, it appears that Judge Campbell's ruling was that the client's motion to dismiss for failure to establish personal jurisdiction was not final. It was without prejudice, and that there was to be continuing discovery on that issue before the judge would make a final determination on the issue of whether the state of Florida had jurisdiction over your client. So I wonder if we have jurisdiction to proceed here.
You do, Your Honor. Let me explain why. There are actually 2 orders that the judge issued. The first memorialized a ruling from a hearing in January of last year. And that ruling, you're correct, was a ruling that was the motion on the jurisdictional challenge was denied without prejudice, and that it could be renewed after there was jurisdictional discovery. In the months that followed, there continued to be additional discovery. There had already been some discovery to that point. And then there was a second ruling memorializing what happened at an April 2014 hearing. And at the end of that second hearing, we have an order, which is tab M in the appendix, that denies Kinjo's motion for good. That order does not say it's without prejudice. That does not authorize renewal of jurisdictional arguments after jurisdictional discovery. Instead, the effect of that order was to require Kinjo to answer, to proceed with merits discovery, and to proceed to trial. In fact, there was a discussion at the end of that hearing about proceeding to trial.
Well, I mean, if you buy into that theory, then it looks like the judge was entering orders that were inconsistent on the same day. And if you look at the discussion and everything that took place at the hearing, it appears that the judge was ruling on a motion to dismiss based on failure to state a cause of action against Blogwire, and I mean, the second order probably could have been worded a little more clearly, but looking at the sequence of events, it does not appear that the issue of personal jurisdiction was actually finally addressed and determined.
Well, it necessarily had to be. The court could not adjudicate on its merits the subject of it, whether or not these causes of action stated a claim consistent with the First Amendment, without first exercising jurisdiction over this defendant. And so by definition, by doing that, the court asserted its jurisdiction. And although I don't know why it took approximately 4.5 months to render the order from the first hearing, it's clear on the face of the orders that one is rendering an order that was issued at the January hearing. It actually says in the first line, this upon hearing in January. The second order says upon hearing in April. Now, what the court is doing, and the court at the hearing basically says, right, so that to the extent we're saying, well, is the court saying there should be more discovery? The court says at the April hearing, on the prior motion to dismiss, at that point in time, really discovery had not progressed. And it seemed part of my basis was to allow plaintiff more time to connect Kinjo to the rest of the case. And so at this point in time, discovery has come about. And there was one asterisk to that, which was the plaintiff got up and said, the judge asked, is the discovery with Kinjo, which she specifically asked, I want to talk about the Kinjo motion to dismiss, has that discovery that I contemplated at the earlier hearing been done? And the plaintiff got up and said, yes, it has, Your Honor, with one footnote. There were some documents that we're still looking for that we've sent a meet and confer letter. And the judge said, at that point, If there isn't more coming out of that meet and confer, I'm inclined to grant the motion. And we then got up and said, the documents that were addressed in this letter were actually produced. It was a production of something like 15,000 pages, and we understand we're not faulting the plaintiff's lawyer for missing them in that big stack of documents, but they actually have them, and that's what happened. Then, so the judge is basically saying, consistent with what is supposed to happen under Venetian salami, which is once we've put in evidence, the plaintiff is supposed to come forward with evidence, and the plaintiff at the first hearing said we need discovery. At the second hearing, the judge says the discovery has come about. The judge is saying, if there is not more showing up to me from this meet and confer, that's the only footnote to her discovery order, I'm inclined to grant the motion. So we expected after that hearing to have one of two things happen. One is that the plaintiff would actually come forward with the evidence that we had been waiting for, at that point, 19 months in the case, or that the judge would issue an order that would expressly allow them to do that. And having not done that, and having then proceeded to discuss the scheduling of trial, we understood that to be an exercise of jurisdiction. We properly brought this appeal, although I understand that the court always has the ability to look at its jurisdiction. That issue was in fact fully litigated in a motion to dismiss the appeal, which was then denied by this court. So, but the bottom line for us is that we have an order that in the absence of this appeal would have required us to proceed to answer, proceed to merits discovery, and to proceed to trial. And in the absence of that, we had no choice but to bring this to this court under Rule 9.130.
Okay.
Turning to, as I was starting to say before we raised the appellate jurisdictional question, this defendant at the end of the day, and we've had at the time of this hearing, this defendant had been in this dispute for 19 months, where there had been a lot of discovery, a lot more discovery after the first hearing. What we know is that this defendant has no offices in Florida, it does no business in Florida, it has no bank accounts or other assets in Florida, it has no employees in Florida, and significantly, it played no role in creating, editing, or publishing the content at issue. And yet, 2.5 years in, here we are. Now, as the court, I think, will know, to establish jurisdiction, the plaintiff has to clear essentially two substantive hurdles and two procedural hurdles. The two substantive hurdles, obviously, are the long-arm statute. Was there a tort committed either in or directed at Florida? And also to establish that there is jurisdiction consistent with the Due Process Clause. Second, there are two procedural hurdles. Under Venetian salami, the plaintiff has to plead facts that would, if proven, establish jurisdiction. And then once the defendant challenges those facts, or the facts that would establish jurisdiction, the plaintiff is then required to come forward with evidence negating those facts. Here, the plaintiff has failed to clear those various hurdles. By the time Kinjo's motions were finally adjudicated, as I said, we had been in this dispute for 19 months. We're now in it 2.5 years. And we have a complaint in which plaintiff pled only one fact about Kinjo, which is that it owns the domain name gawker.com, which is not certainly enough to establish anything that would remotely subject it to jurisdiction in the state of Florida, because that is not in and of itself a tort, let alone a tort directed at Florida. Plaintiff provided no evidence, none. Plaintiff pointed to no act directed in or directed to Florida. Plaintiff pointed to no evidence that would establish that Gawker is a sham or a shell being misused by Kinjo to defraud creditors. Plaintiff pointed to no contacts with Florida, no conduct in which Kinjo purposely availed itself of the protections of Florida's laws, and no basis for a group of Hungarian software engineers to anticipate being hailed into court here in Florida. And that's particularly important because the U.S. Supreme Court has repeatedly emphasized that in addition to the normal due process considerations that apply when evaluating jurisdiction, there are added considerations of international comity when we're dealing with a foreign, and I mean foreign, not U.S. corporation, as most recently expressed in the Daimler case, in which there was an effort to sue Daimler based on the operations of Mercedes-Benz USA, and the Supreme Court said you can't do that, and that it causes all sorts of problems for us in our international relations when courts try and assert jurisdiction in that way. This is what the motion says, and this is what we were before Judge Campbell twice on. Now, what plaintiff doesn't really respond to any of that. Instead, the plaintiff's primary argument is that he is entitled to still more discovery. And look, we don't dispute that a trial court can order discovery for jurisdictional purposes. But the point of that, under the Leondakos case, is that the discovery is supposed to be limited because the court, if the court ends up not having jurisdiction, it should really tread no more than is absolutely necessary on this defendant to figure out that question of whether it has jurisdiction. So, but in this case, after the 2 rounds of discovery that preceded this motion, and certainly since then, the plaintiff has had the very discovery he needs to address the legal questions before the court. He has taken exhaustive discovery about who wrote and edited the article at issue. He had interrogatory responses, some of which are in the record, every document on that subject, and the deposition of the author/editor and the managing editor. There was literally no reference to Kinjo or anybody from Kinjo in any of that discovery. So there was no argument that they participated directly in the tort, and they've admitted as much in the trial court. There's also no evidence that Gawker is a shell or a sham established by Kinjo to evade creditors in a way that plaintiff can hold Kinjo responsible for Gawker's publication on some sort of veil-piercing theory. He's taken exhaustive financial discovery on this question. We have produced 4 years' worth of income statements. We have produced 4 years' worth of balance sheets. We have produced 3 years of financials that were either reviewed or audited by outside auditors. The 4th year we haven't done yet because it's for 2014 and it's still not done. We have produced monthly revenue reports for 4 years. We have produced copies of every order form from an advertiser to place advertising at Gawker for a 4-year period. We have produced detailed bank records of every license fee payment from Gawker to Kinjo for this software license that's at issue for 4 years. We have produced Kinjo's financials in Hungarian. They're actually in Hungarian language, provided and prepared by its Hungarian CPAs. We had a full-day deposition of Scott Kidder, the managing director, and in the papers you'll see that the plaintiff creates as the boogeyman behind all of this Nick Denton, Gawker's CEO, who owns not all but some significant portion of the shares of the parent company. They also had an opportunity to pose Mr. Denton for a full day. That discovery shows conclusively that Gawker is not a shell, it's not a sham, it's not a mere instrumentality of Kinjo. Instead, it's a fully functioning company. It employs more than 100 employees. It houses them on multiple floors in an office building in New York. It publishes 8 websites with more than 100 million unique visitors every single month. It sells tens of millions of dollars in advertising and generates annual revenues in the tens of millions of dollars. This is not a sham. And if any of this discovery were to show otherwise, the plaintiff would have gone to the trial court and said, here is the smoking gun that shows that either Kinjo participated in publishing the article at issue and therefore is responsible for directly committing a tort either in or directed to Florida, or they would have gone and said, here is the smoking gun that shows that Gawker is actually a sham and a shell and its corporate form should be disregarded and that you can go through Gawker to get to Kinjo in Hungary. Now, they say they still need more discovery on this point. But the reality is you can always stand there and say you need more discovery and try and forestall the dismissal of the defendant. But the whole point of a case like Leondakos is to say that has to be narrowly circumscribed. So the argument, and picking up, Your Honor, on your question about what Judge Campbell was doing, we have a situation where Judge Campbell basically said discovery has come about and put one footnote on it, and other than that, the trial court, which is in the best position to know, said the discovery is done. And the plaintiff has argued, well, this is a discovery ruling and you should address that by an abuse of discretion review. But if that's true, then you should also address Judge Campbell's finding that discovery has come about, and unless there's more coming out of this meet and confer, I'm going to let Kinjo out of the case, and you should not upset that finding by saying you still need more discovery after 19 months of that discovery. So, and I just want to emphasize that that this is particularly sensitive here under the Due Process Clause because there are no contacts with Florida, let alone minimum contacts.
Mr. Berlin,
yeah.
I've let you go a couple minutes beyond what you would have given the jurisdictional discussion. but you're down to your 7 minutes, so do with them what you wish.
I will use about another 30 seconds, and then I will keep the rest if I may. I just want to finish by saying that this is a particular sensitivity under the Due Process Clause because Kinjo did not do anything by any objective measure that would be having contacts with Florida, purposely availing itself of the privileges of Florida, would make it foreseeable that this group of software engineers would be hailed into court in Florida, and that's particularly important under the Supreme Court's Daimler case, which was decided just before the first of these two hearings, brought to the court's attention, and not really credited, if you will, by the trial court. And for that reason, Your Honors, we would respectfully request that the order asserting jurisdiction over Kinjo be reversed and that Kinjo be dismissed with prejudice from the case. And I'll reserve the balance of my time if I may.
May it please the court, good morning. My name is Ken Turkel, and along with Steve Cohen, we're here on behalf of Terry Bollea, who is also known professionally as Hulk Hogan. I believe the prudent place to start our argument is exactly where Judge Wallace was at the beginning. The threshold question here is whether there's any non-final appealable order before this court. Your Honor, we raised that by a motion to dismiss, the motion panel denied that. However, under Bill Holt, which was one of the cases we cited in there, this court can revisit and re-examine a motion panel's ruling on jurisdiction, and we don't think there's any jurisdictional predicate in this record. The simple truth is this: there were two hearings, there were two orders, albeit signed on the same day. The one hearing that was had on their motion to dismiss for personal jurisdiction in January of 2014 resulted in a very clear order by Judge Campbell stating that she was going to defer ruling and allow jurisdictional discovery to occur, subject to the appellants refiling their motion to dismiss after jurisdictional discovery had occurred. That didn't happen. As we sit here today, there is no order that resulted from an evidentiary hearing on their motion to dismiss for lack of personal jurisdiction in this case. It simply never happened. What Mr. Berlin described...
Well, let me ask you this.
Yes, Your Honor.
They had a pending motion to dismiss for lack of personal jurisdiction, correct?
Yes. Well, pending to the extent that Judge, technically what she told them to do is to renew the motion after jurisdictional discovery had occurred.
But the court denied the first motion.
Without prejudice, yes, Judge.
Without prejudice, with prejudice doesn't make much difference on a non-final order, does it?
No, Your Honor. I think just the only thing I would point out was she was expressed in that order as to the reasons it was denied without prejudice, which was to allow jurisdictional discovery to occur.
I understand. But and that order was entered the same day as the written order was entered the same day as the other.
Yes, the orders were submitted and for some reason were signed on the same day.
Technical matter. We have an order that denies a motion to dismiss for lack of jurisdiction, personal jurisdiction, that was appealed within 30 days.
Judge, I don't know which order you're referring to. You're referring to the one arising from the January hearing that was rendered on May 14th?
Yes.
Correct, Your Honor. However, what never happened, and I think where the appellant is being a little creative with our record here, was the April hearing was expressly on the merits of their motion for failure to state a claim. And when I say expressly, I don't mean...
Yeah, but, we're back on, you guys contend and have contended that we don't have an appealable non-final order. But I'm looking at an order that denies a motion to dismiss for lack of personal jurisdiction in writing, albeit saying they can refile it later if they want, and a notice of appeal within 30 days of that.
Judge, and I mean, we framed, I think, that's kind of what we framed in our answer brief, which was, to the extent there is an appealable order, right, they would simply be appealing whether Judge Campbell was allowed to defer ruling and allow us to conduct jurisdictional discovery, which under Glen Eagle, I think that's not how they're really arguing their appeal. What they're arguing is as if we had had an opportunity to present all the evidence. And
So is it your position that the alleged lack of personal jurisdiction is still on the table?
Absolutely, Judge. It's our position, and I believe it's their position, if you look at the record carefully, that there was never a final hearing on their motion for lack of personal jurisdiction. In fact, in their response papers, when they re-noticed, for lack of a better term, and Judge Wallace, I think this is where you were getting at with what the record discussion was, when they re-noticed their motion to dismiss, because in their original motion to dismiss that raised personal jurisdiction as to Kinjo, they also had general failure to state a claim. They re-noticed it. We file, our co-counsel from Los Angeles, Harder, Morrell, and Abrams, files a opposition to that, saying, to the extent they're trying to get another bite at the apple on the threshold jurisdiction motion, they can't do that. It's been ruled on. They respond, and in their arguments, in what they, it's in their record appendix at K, what they write in their reply in further support of motion to dismiss, and I want to quote it as follows. Plaintiff complains that the court denied Kinjo's motion to dismiss in January 2014 and accuses Kinjo of attempting to seek reconsideration of the court's order. That simply is not correct. At the January 17, 2014 hearing, the court and the parties, including counsel for plaintiff, addressed only the question of whether Kinjo is subject to the court's jurisdiction and had sufficiently alleged jurisdictional facts in its complaint. Kinjo expressly reserved its arguments about plaintiff's ability to state a viable claim on the merits. It is now asking the court to rule on that question. If you look at the conversation, I believe it's at tab L of their appendix, which is the transcript, my co-counsel, Charles Harder, says to Judge Campbell, I guess what they're doing right now is taking the position that they reserve their argument on the merits and will go forward on that. And as Judge Campbell sort of falls into some questioning about jurisdiction, he says that's not before the court today. There's sort of a dialogue with the court, but what there isn't is the submission of any evidence.
Well, let me come back. If we, at least under this order, would we be in a position to assess the sufficiency of the jurisdictional allegations in the complaint?
When you say again, Judge, this order, you mean?
The order that they're relying on for jurisdiction.
I think you could probably look at the jurisdictional allegations to see whether they comported with the pleading requirements.
So
however,
we do have jurisdiction. The question is, what is the scope of the review?
I think it's very narrow, Judge. I think it's...
Well, but I mean, that's what the issue is.
Yes, and no, I'm not conceding you necessarily have jurisdiction, Your Honor, because if we look...
well, I mean, they've got a motion that alleges lack of personal jurisdiction. One of the grounds is you haven't adequately pled it or pleaded it.
They've put that in there amongst many other things,
well,
that the allegations...
They put that in there.
Right.
So that was on the table at the first hearing.
Correct.
The judge denies that motion.
Correct.
That doesn't require additional discovery.
Correct, just the pleadings.
And the order is entered.
Right.
And so what I'm saying is the question really here is not whether we have jurisdiction. The question is what is the scope of the review based on the jurisdiction?
Judge, I think, yes. I think if we want to, and we briefed it that way in our answer brief, which is to the extent there's jurisdiction, it is over the narrow question of whether Judge Campbell abused her discretion in allowing jurisdictional discovery when there was a pending motion to dismiss for lack of personal jurisdiction. And secondly, you could look at the pleadings issue and, remand with leave to amend. We didn't get a chance to amend if that were the case. And certainly we could amend, although I think based on precedent, and I think we had cited a case, the Al-Nayan case, the idea that you're pleading is sparse in these contexts doesn't really provide a basis to reverse. We certainly complied with what 48193 requires.
Are there affidavits filed that address the jurisdictional issue under Venetian Salami?
No, Judge, there were no counter affidavit filed, although I would say that in Glen Eagle at page 1284, I think the court somewhat elegantly puts out the procedure for us and says you can make averments in good faith, although they may not rise to the level that you can swear to them. As the plaintiff, you shouldn't be required to swear to them. The whole purpose of Glen Eagle was to allow you to conduct your discovery and to use the court's words. Thus, a plaintiff should be able to conduct limited discovery on the jurisdictional question in order to gather facts.
I'm wondering if Blogwire filed affidavits addressing the jurisdictional issue.
Blogwire did, yes, Judge. They filed evidence. I believe there was affidavits in there. I think the process, as we argued it, and I think as Glen Eagle, he calls it Leonidas. I tend to go with the first name of the case. But the whole premise of that case was sometimes when you're a plaintiff, you can make averments in good faith that don't rise to a level you can swear to, and you should be afforded the opportunity to do your discovery, as stated by the Supreme Court in that case, to gather facts to file your opposing affidavit. The procedure, what Judge Campbell did at the first hearing was a very routine order on jurisdiction. This happens very often. She gave us a chance to do jurisdictional discovery. Contrary to what Mr. Berlin and appellant have argued, the jurisdictional discovery was not done. In the record, there are numerous places, at tab G of their appendix, page 89 through 90, at tab J of their appendix, which is our opposition to the renoticed motion to dismiss, and in our own appendix at tab D, we served interrogatories on May 1st. They hadn't even come due yet when they appealed the order. The discovery he's talking about, and if you read the transcript from the April hearing, which is at, I believe, tab L of their appendix, you see my co-counsel saying, yeah, that's not exactly true. We still have discovery outstanding. We've taken some merits discovery. But at the time we filed our answer brief in this, we had not gotten our discovery.
Certainly, you know, if there was to be a contested evidentiary hearing on the issue of personal jurisdiction, you never got to that point, and that never happened.
Absolutely. We never, what Judge Campbell's order contemplated, and again, I hate to refer to anything in what we do for a living as routine, but it contemplated the process of finishing the jurisdictional discovery, then presumably they would renotice their motion, and we'd go to have an evidentiary hearing. We never had that. And if you read the April transcript, even just skimming through it from that hearing, the parties had expressly agreed, and in fact, appellants briefed it as if it was only going to be on the merits. Now, the best I can tell, Your Honor, as to what they're actually saying now is this, and it showed up in their reply brief. The trial court could not have adjudicated the substantive merits of Bollea's claim against Blogwire Hungary unless it possessed personal jurisdiction, which I think at its best implicates invited error. Following through, I think Judge Crenshaw and Judge Walsh, you were both on Tate v. Tate. Judge Walsh, I think you wrote that opinion. This idea that they're kind of telling the judge, well, you've told us you don't have jurisdiction yet over us, but we're going to go ahead and argue as if you do, and then we're going to come back and complain about the ruling you enter. The Fifth District just released an opinion, Quail Point, I think it's called, Alexander versus Quail Point. It's only a Westlaw site, where it said invited error applies whether invited solely by appellants or agreed to by all counsel. In other words, everybody agrees right there that we'll go ahead and let them argue whether we state a claim as to alter ego liability against Kinjo. And then when the judge rules on that, all of a sudden now this has become the final hearing on jurisdiction, which if you really look at the record, Judge Wallace, I agree with you completely. That's just not what the discussion was. I don't know how, frankly, they're not even judicially stopped from saying it when they put in their own briefing papers, plaintiff has understood for many months that the court has yet to rule on Kinjo's arguments about the merits of plaintiff's claims and that Kinjo is not seeking reconsideration of jurisdictional issues already adjudicated. I read the previous paragraph from his reply in support of his motion, where it says it is asking the court to rule on the merits. And so I think at best, reading the reply brief, which is kind of like, she had to be ruling on the merits because, I mean, she had to have determined jurisdiction because she ruled, that's just not what everybody said. It's not what the record says. And I think, as I stated, you know, at best it's invited error, and at worst, they've waived their right to contest jurisdiction because they submitted themselves to the jurisdiction of the court on that day. They intentionally relinquished it. If they want to play this card that by hearing their argument, the judge had somehow now had the full-blown evidentiary hearing to which we are afforded under Glen Eagle. The simple truth, Your Honors, is that we never got that hearing. It never occurred. It is a fiction in this record. Moreover, the laundry list of discovery that appellant argued they had provided is nowhere in this record. What is in this record, both in our opposition papers to the underlying motion and in the transcripts, is our contention that we've never finished jurisdictional discovery. This shouldn't be where it is right now. It should have just simply proceeded as most of these do. You have your first hearing. If there's conflicting or there's no evidence and there's a motion to continue or to take the jurisdictional discovery, Glen Eagle tells us what to do. And we were proceeding down that path, and you know, I don't know whether the fact that the judge, the court entered her orders on the same day somehow allowed, you know, for this predicate, but I don't know how this record can be read to see that there was a full evidentiary hearing. That's why when Mr. Berlin and the appellant argue that there's no record evidence of this, that nothing was filed that day. Nothing was put into the record that day because that's not what the hearing was. And you can see that from the first 2 or 3 pages of it and from the briefing that was filed in the underlying court. There are a number of cases that we've cited, the Zapata case, bill hold sales, other cases that allow the court to re-examine the ruling of the motion panel, and I do believe that there's no jurisdiction here. Judge Northcutt, as to your question, if there is jurisdiction, it's on 2 very simple questions. One, whether Judge Campbell was correct in ordering jurisdictional discovery, which I don't know of a case that disallows it in the context of what happened here. Glen Eagle makes it very clear. All of its progeny makes it very clear. We were following that process, and there's no abuse of discretion there. Secondly, Your Honor, as to the pleading issue, I would direct the court to the Al Nayan case that we cited in our answer brief. It's a 5th District case out of 97 in which a similar argument was made. You know, and it kind of went like this. The allegations regarding liability are sparse. They're not the best. However, there was this affidavit, there was an accuracy question, there was going to be discovery, and because the question of jurisdiction and a service of process issue shared a common factual issue, they were entitled to test it. There was the same kind of idea, Judge. We pled the language of 48193. What their argument has been was by defining this network of Gawker entities together, we're sort of just playing semantics, but the truth is, those are what the allegations state. And at that level, the allegations are taken as true, inferences are taken from them as true, and then you go to the next level, which is the evidentiary hearing. And so we've alleged that these companies all conspired with each other. They were all principal and agents with each other. The whole idea of this, when you have a Hungarian company that purportedly, and I say purportedly because we're still testing the veracity of everything this company does, is networked with this entity that published this surreptitiously recorded sex tape. The whole idea is that we test what the defendant's saying. That's what Glen Eagle said. We're not supposed to rely on their affidavit, and so we just want to be afforded that process and put that discovery before the court, have a final evidentiary hearing, and then if Judge Campbell rules in a way they don't like, they can come back on that. But at the end of the day, the allegations comport with the cases that have reviewed these for allegations. I don't know what to say about Judge Campbell's ruling on the deferred ruling for discovery purposes. That is just the process. We're allowed to do that. There's not a case in the context of what's happened in this that disallows it, and it's clear precedent. And so as a threshold matter, we would ask that this court re-examine the motion panel's ruling and dismiss this appeal for lack of jurisdiction. If the court finds that there is a limited scope as to the January order, we would ask that worst case scenario, if the court finds the pleadings don't comport with applicable law, that we be given a chance just to amend the pleading in that respect as to this defendant. But we believe it does comport with applicable law, and ask that Judge Campbell be affirmed on that issue, and additionally on the issue of the narrow issue of deferring this for additional discovery with instructions that follow the order, which is for the appellant defendant to renotice their motion so we can have the hearing that the law affords us and vet these issues out completely. Absent any other questions from the panel, that'll conclude our position on this.
Thank you, Mr. Turkel. Berlin. I got you right about 6 minutes.
Let me try, if I can, to bring some clarity to what I believe is admittedly not as clear a record as it can be. I believe that there is clearly, as Judge Northcutt, you intimated by your questions, jurisdiction over the first of these two orders, because it is clear that there was a ruling on a motion to dismiss for lack of jurisdiction. I would respectfully submit that there's also jurisdiction over the second order. The motion, if you look at it, and this is in the paper, has one sentence about the merits on the First Amendment grounds, joining other defendants to the extent that there was jurisdiction. And we were very clear that it would be that way for the purposes of saying, if there is no tort, right, if this is protected speech by the First Amendment, as this court had previously ruled in the temporary injunction context, if there is no tort at all, there is certainly no tort that is being directed to Florida or in Florida. But we were very clear that all the way through that we were preserving the jurisdictional argument. Some of the language that was taken out of context by Mr. Turkel is in response to a curious argument. In this court, the plaintiff has argued there was no final adjudication of jurisdiction, and therefore there's no jurisdiction for the appeal. In the court below, they argued the exact opposite. After the first motion was denied without prejudice to being renewed, when we sought to renew it, and we noticed a renewed motion, they said, you can't do that, that's already been adjudicated. And we made 2 points. One is it was adjudicated without prejudice, and two is it didn't adjudicate at all any of these First Amendment issues that we were joining the other parties with. So we made those statements. It is clear from the hearing transcript at the second hearing that Judge Campbell did take up the First Amendment arguments, and although she could have ruled, if she had ruled in our favor, it would have been a ruling tantamount that there's no jurisdiction over Blogwire because there was no tort. When she ruled against Blogwire on that and the other defendants, she was essentially saying there is a viable cause of action, and she was therefore obliged to address whether she had jurisdiction to actually do that, and she properly took that question up and went into an extended colloquy with Mr. Turkel's colleague, Mr. Harder, about the discovery that had been done. Was it done? Saying the discovery has come about. And if at the end of that hearing, right, we thought that we were surprised when we got the second order, because the second order should have said, if she was going to continue, that with respect to Blogwire Hungary, I find that this is still going to go on, and there's going to be a new motion, or there's going to be additional jurisdictional discovery, or there's going to be something about a meet and confer resolution, or whatever it is that she's saying. But instead, that order says that Blogwire Hungary's motion is denied. Full stop. And if you deny a motion to dismiss, which includes, for all but one of its sentences, jurisdictional challenge, you are essentially ruling on the fact that you have jurisdiction. And the net effect, under the rules of the circuit court, is you've got to go and then answer. And you've got to go and proceed to merits discovery. And so this is not invited. I'm sorry. I'm sorry?
Referenced in that order, the motion to dismiss of Kinjo, KFT, in that order, is the same motion to dismiss that's referenced in the other order.
Is that motion...
I mean, you have,
we noticed
you have a single motion to dismiss that alleges lack of personal jurisdiction, and
in a sentence that we would join the other ones.
That's it. That's the motion to dismiss.
That is the motion, and we noticed that and said we renew that motion, which is what the judge had instructed us to do. And the reason for that is our side of this story on the jurisdictional challenge had not changed. Our side of the story was that the pleadings were defective and that the evidence, and Judge Wallace, you asked the question about the affidavits. We had submitted evidence, deposition testimony, affidavits, sworn interrogatory responses, and our record was still the same, saying this company has no connection. And what was tellingly absent from anything that Mr. Turkel said was any evidence that suggests after 19 months of discovery, and all of the discovery that the judge said when she said discovery has come about, that there's actually any evidence that links Kinjo to this case on either of the legal theories that they've advanced. And in the absence of that, whether it's a proffer to the court, whether it's a motion in this court to relinquish jurisdiction to supplement that, there is no, at the end of the day, and this is really the problem, and this is what I'm I'm trying to get at with relying on Glen Eagle or Leondakis, whatever you want to call it, is that at some point a party has an entitlement under the Florida rules and certainly under the Due Process Clause to have a reasonably prompt adjudication of its jurisdictional challenge. And we would respectfully submit that after 19 months, when the court itself is saying the discovery that's necessary has come about, that after that, we are entitled to get out of this case. And in the absence of hearing from the other side, here's the evidence that keeps you in the case, we ought to be out. And so the request that we conduct a narrow review only on the first order of the pleadings, or that we send the thing back, or that we allow for amendment of pleadings when there's actually been an evidentiary showing, is just delaying the Kinjo's ability to actually get to the merits of its jurisdictional challenge and get out of the case, which it has been trying very hard to do for, a number of months, including through 2 hearings in the court below. And that at the end of the day, this is not invited error, but this is a judge who's saying, I think discovery's done. Footnote, is there anything from this meet and confer? And otherwise, I'm going to send Kinjo out. And then, curiously, we were surprised, does the exact opposite and says, no, you're in. And having done that, that is a jurisdictional, if nothing else, it's a jurisdictional determination. It's one that is properly before this court. It is one that is wrong under the established principles of the law. It's wrong under Leondakis in terms of needing still, even if you said, oh, well, it's still more discovery, but that's not what the context for the order says. And at the end of the day, we're now, this dispute started in October 2012. We're now into 2015, right? At some point, and I'm not aware, look, we're in the trial court with the remaining defendants set to go to trial in 3 months' time and discovery set to end in less than 30 days. I'm not aware of another case where the jurisdictional challenge for one of the defendants has gone on so long that it bumps up against a trial, right? This is a fundamental problem of due process, and it is, the plaintiff says, well, we wanted to take more discovery, or we needed to do this, or we needed to have a hearing. It had a very long time to do that, and it's not entitled to sit on its hands and delay the ultimate day of reckoning in what we would respectfully submit as a pressure exercise to sort of apply pressure to this whole corporate structure to get it to settle. So,
You'd wrap up.
all right. Well, I would just then, again, respectfully request that the court, A, accept jurisdiction over both of these orders, B, conclude that they were issued in error, and C, reverse, and D, dismiss Kinjo with prejudice. Thank you.
Thank you, Mr. Berlin. Thank you both.